If you have been charged with an OUI, then you have either received a summons or been bailed for a court date. The court date on the summons or bail bond is for the initial appearance. The initial appearance is the first court date. If you do not have a lawyer, you must appear in court on this date. The judge will ask if you understand the charge and what the maximum penalties can be if convicted of the charge. If the charge is for a misdemeanor, which most OUI charges are, then the judge will ask for a plea. You can plead guilty, not guilty, or no contest. If you enter a guilty or no contest plea, then you'll be given up your right to a trial, and the court will enter a guilty finding and impose a sentence. Any OUI conviction requires a mandatory license suspension of at least 150 days and a fine of at least $500. Some OUI charges also involve mandatory jail time. You should be sure you understand the minimum penalties and any recommended sentence by the state before entering a plea of guilty or no contest. If you enter a not guilty plea, the court will schedule the matter for a second court date called a dispositional conference. If you hire a lawyer before the initial appearance date and the charge is for a misdemeanor offense, which again most OUIs are, the lawyer can file an appearance and not guilty plea on your behalf. Once this has been filed, you will not be required to appear in court on the initial appearance date, and a dispositional conference will be scheduled. The dispositional conference is a meeting between the lawyers and the judge to determine what the next step in the case will be. The options at the conference are 1. To file a motion to suppress evidence if there has been a constitutional violation, such as an illegal stop. 2. Schedule the case for a trial. Or 3. Reach an agreement to resolve the case. If a plea agreement is reached, it can be entered at the dispositional conference and the case will be over. If a motion to suppress is filed, the court will schedule a date to hear and decide the motion. If the motion is successful, it will result in evidence being suppressed and often dismissal of the charge by the state. If the motion is denied, it does not mean you are found guilty of the charge, but that the evidence can be used against you at trial, and the court will then schedule the case for a docket call. The docket call is a court date when the judge goes through a list of cases that could go to trial during that trial period. In many courts, the docket call is scheduled once a month. In some of the more rural courts, it is held less frequently. The docket call is one of the last chances to try and resolve the case with the state before a trial. If a resolution is not reached, the case will be scheduled for trial. If you choose to have a jury trial, the jury selection date will be the next court date. At trial, you are presumed innocent of the charge. The burden is on the state to prove the charge beyond a reasonable doubt. If you have a jury trial, all 12 jurors would have to vote guilty in order for you to be convicted. The trial will be a public trial, and you would be present throughout the trial. Any witnesses called by the state have to testify in court and can be cross-examined. You have the right to call witnesses on your behalf, but are not required to call any witnesses. You have the right to testify at trial or not to testify. The state cannot call you as a witness against yourself. If you decide not to testify, that cannot be used against you or considered in any way in deciding whether the state has proven the case. If the state fails to meet its burden of proving the charge beyond a reasonable doubt, you would be found not guilty and the case is over. If the state meets its burden of proof and a guilty verdict is returned, then the matter will be set for sentencing. If you are convicted after trial, you have the right to appeal the conviction and any motions denied by the court. You can also appeal any sentence of more than a year, which would only apply in a felony case, to the Maine Supreme Court. This is a summary of the court process in a Maine OUI case. It is advisable to consult with an experienced OUI lawyer before making any decisions on how to handle your case.